IALS, and I wanted to make some brief final remarks to thank you all before we open to the past presidents and the celebration of 75 years of the IALS. And in typical fashion, thinking that I would be technologically advanced today using technology instead of my papers as usual, my phone is not cooperating, so I'll be doing it from memory originally. I want to first particularly thank Professor Inal and Professor Nat and the colleagues here, Professor Assoc, and others who have been instrumental in putting together such a remarkable program for our symposium in the 75th year of the IALS. In addition to that, I particularly want to acknowledge the support and the efforts of our President, Elina, and Professor Agustín, PARISE, and thank you sincerely for your support and help. We've been fortunate to be here for 2 days, not only in such wonderful and marvellous settings, but to experience the expertise and the research that the colleagues have brought together and shared with us over a range of subjects, beginning with our first panel, when we were introduced to the breadth as well as the depth of AI and the imminent presentation about AI disruption, reminding us as Emeritus Vice President, Professor Sjef, of the importance for us as teachers and educators of supporting our students to work and to understand ourselves as technology that they are going to be working with if they're not already doing so, and how we can do that with integrity and transparency and trust and honesty. These themes have gone through the whole 2 days of the presentation of the work, and while I was not able to be part of the round table, but just before this session now, I understand that it was, again, a wonderful, rich success of papers and presentations from colleagues who are experienced developing their expertise as young scholars. What we take away from these 2 days is that we're at a time of great change, not only within our profession, within our scholarship, but also, as we're all aware, geopolitically. And that behooves all of us, those of us who are established, scholars, academics, lawyers, students, to work towards the aims of the IALS established in 1950, to develop the world, to develop peace through legal science and through comparative legal science in particular. More than anything, we need the skills that all of us can bring to bear to foster the transparency, defence of the rule of law, defence of the principles that our colleague talking about tax compliance and regulation placed so clearly on her slide to conclude her presentation about legitimacy, democratic principles, rule of law, public trust, rights of people to have dignity in their daily lives. I hope that for the students who've been so tireless in their support of our symposium these last 2 days, I hope you've been able to see and enjoy the opportunities here that you've seen before you, but most particularly I encourage you, along with the rest of us, those of us who are privileged to have education, to be lawyers, to be scholars, to have the responsibility of prosecuting these tasks before us. I most particularly want to thank you all for the work that you've done for us here in supporting the symposium. I thank all of you here still this afternoon for the work and contributions that you have made, and I thank in particular the colleagues who will now be speaking to us to remind us of the heritage of this association, and I look forward to working with you all to continue that very strong tradition. Thank you very much.
Madam President, Mr. Presidents, members of the Executive Council, colleagues, students, and public at large. I hereby welcome everyone to the commemoration of the 75 years of the International Association of Legal Science. It is a pleasure to share some opening words in my capacity of Secretary General. It is difficult to think of a more suitable city for our event today. Istanbul, being not only unique and beautiful, it is a meeting point of different continents, cultures, and traditions. Well known as a gate to the east, but also as a gate to the west. It's always lent to changes in every form. Lending to exchanges is one of the pillars of the IALS, as stated in Article 4 of the statutes of our association. Our event today consists of two parts. In the first part, we will engage in dialogue with former presidents of our association. Our current president, Elina, will moderate that panel, posing questions to former presidents Ergun, SYMEONIDES, GAMBARO, and Sjef. We are grateful and we look forward to their authoritative insights on the insights. In the second part of this commemoration, we will give the floor to Oleksiy, KRESIN, who is the current Director of Implementation of our association. Our colleague will guide us through the origins and history of our association, while inviting us to reflect on the present and therefore helping us to look firmly towards the future. In both parts of this commemoration, attendees will have the time and space to raise questions and to share comments. Some friends are joining via Zoom today, crossing continents, oceans, and time zones. We expect a lively dialogue. I want to help in paving the path towards these two parts of the event, towards that lively dialogue. And in doing so, I will share a few remarks on the need for gratitude and the need for action. Let me start with some reflections on gratitude. We need others and others need us. Even Don Quixote de la Mancha had his own Sancho Panza. There is great value in being grateful. We need to acknowledge the generosity, the time, and the efforts of others. They deserve it. I will cluster my feelings of gratitude in 4 groups. First, gratitude goes to our hosts today, in the past, and in the future. We are able to gather almost every year and in seminal cities across the globe. Our global presence is undisputed. Our hosts today are gathered around the IALS Turkish National Committee and the Center for Comparative Law of the Faculty of Law, Istanbul University, and their ambassador is Emran İnan. This is the 5th time we gather in magical Istanbul, with meetings held in 1955, 1997, 2004, and 2010. I know the future will continue bringing us to the pearl of the Bosphorus. Second, gratitude goes to UNESCO and to the International Science Council. IALS is the only member of that council that represents the scientific field of legal science. We should not take it for granted. This entails responsibilities and actions. This entails that we are the guardians of legal science in that important habitat. It must be clearly present, protected, and valued. Third, gratitude goes to those who make the IALS a reality. The IALS operates through the Executive Committee that is led by a president and aided by a number of officers. Let me express our gratitude to the current president and to all who preceded her in an uninterrupted chain since 1950. Secretary Generals can be considered the oil of the engine, and the gratitude should go to my predecessors, especially to Mina Lecker, who served in that position during 9 decades. The Director of Scientific Studies helps secure that IALS stays connected to the most recent developments in legal science. They are an important bridge between law and society, as attested in the program of the event that gathers us today and yesterday in Istanbul. Gratitude goes to the Director and her predecessors. The directives of documentation not only help attest to the developments in law, but also on the life of our association. A word of thanks goes to our director and to the only colleague that preceded him, the eternal Felipe de Sola Elisa. The national committees are the branches of the tree. They have ALS outreach to all continents, inviting for the engagement of different actors in the developing of comparative law. The tree would suffer without those branches, yet it needs water. And the members of the executive committee are that water. They are nurturing the life of IALS, being indeed needed and present at all times. Fourth, and certainly not least, gratitude goes to the legal scientists from now, from yesterday, and from tomorrow. We are all indebted to the legal scientists that joined our symposium and that contributed to our publications, be these through journal articles, chapters, mailing, volumes, or monographs. We are indebted to those legal scientists as traveled in mind and body, who devoted time to academic gatherings during the past 75 years. To those who raised their hands and shared questions and comments and engaged in academic dialogue, such as the ones that we experienced during the past 2 days in Istanbul. We are ultimately indebted to those who devoted time to think about the value of law as a tool for change. Before I move to the call for action, please join me in thanking all of those who I just mentioned by means of a round of applause. They deserve it. Again, we should not take all those efforts, all your efforts, and all your generosity for granted. I will now share for a few minutes a few action points looking towards the future. Esin Oruku from Turkey, the international, stated once that the human element is the most important factor. I here invite you to engage in an exercise in which we will explore action points. The first action point relates to the need to generate synergy among actors. Let comparative law bring us together, within and beyond the IALS. We need to listen to old, to current, and to new voices. We need to engage with other jurisdictions and to embrace dialogue with other systems. An upward spiral of legal science can be attained by building teams. Isolation would be detrimental to the development, producing intellectual inbreeding and thus threatening the development of legal science. A second action point relates to the need to be curious and global actors. Legal science evolves in many ways. Academic curiosity opens paths of exploration and ignites awareness on the needs of society. It can take legal scientists to different places, exposing them to other cultures and ideas. We must be open-minded and engage with otherness. A third action point relates to the need to be active and thorough actors. Members of IALS should continue being active in the comparative law environments, the International Academy of Comparative Law, the World Society of Jurisdictions, Juris Diversitas, Enrique Capitan, just to mention a few scholarly hubs, all need ambassadors from IALS. Ambassadors should be thorough and aim to excel. A fourth action point relates to the need to be open and creative. Comparative law will continue building and nurturing its own path, yet it should be resilient. Legal scientists must allow themselves to be surprised by the details in the law and in society, by the unexpected, by the daily evolution in the life of the law. A fifth action point relates to the need to look to the future while being grateful of heritage. Legal scientists need to be on top of developments, on relying on the new technologies, be acquainted with the most current trends. I think the theme of this symposium is a good testament of that action point. Yet, there's also need to cherish and protect heritage. law is meant for a society at a certain time. The needs of society are embedded in heritage and should be protected. Let us continue making IALS a powerhouse for comparative law. Legal scientists across the globe are open to receive the tools and the solutions that are put forward by the IALS ambassadors. To conclude, we gather today to celebrate these 75 years and to look forward to meetings that will come in the future. Together, IALS has developed tools that help us understand what is happening, that help us adapt to the changes into the needs, and that help us visualize how legal science is a fundamental pillar of law in society. On the occasion of the Diamond Jubilee of the IALS, I can say that I strongly believe all is set for future generations to continue carrying high and bright the torch of legal science. Thank you very much. I now give the floor to Professor.
Thank you, dear Professor PARISE. Thank you, dear Agustín. It was, your words very well, perfect, and we are very grateful for them. I'm really moved, you can see that. I consider it a great honor for me to be president of this association, which had such presidents in the past. And I have the honor to coordinate this small decision about comparative law and about the past, the present, and the future. I thought about putting 3 questions to each one of them, but let me first say hello to everyone and welcome everyone. So Professor ÖZSUNAY, so thank you very much for the hospitality first. And I'm very glad to meet you again after so many years. We have met in several occasions, but I first met Professor ÖZSUNAY back in 1994 at a conference of International Academy of Comparative Law, Athens. Yeah. A very good friend of Professor Emeritus and Professor Bayes. So, Professor SYMEONIDES, okay, we'll show the video afterwards. Okay. Professor Antonio GAMBARO, we miss you really. We would like you to be here, but we fully understand. We are very happy to see you online, at least online. And Professor Valer, we are Sjef. So we are very happy, and I am very happy and honored to have you here and to ask you the following questions. Perhaps 3 questions, perhaps one by one. First of all, when you were president, what was the global context at that time, and what are your memories of your time at International Association of Legal Science? Let me ask you first, Professor ÖZSUNAY.
Question or
all of them, perhaps all of them.
I would like to make.
Okay, so let me make all the questions together. I thought it would be easier, but you're right. So the second question: what are currently the main challenges for comparative law and for the International Association of Legal Science? For example, what do you think about the new approaches to comparative law? Comparing legal cultures, comparing legal traditions, comparative law and comparative literature, comparative law and economics, in this case focusing mainly in legal transplants. And the third question, what are currently the main advantages for comparative law and for the International Association of Legal Science? For example, would you say that interdisciplinarity has contributed to a deeper study of the various laws of the world and therefore to a more accurate comparison of them? If not, what are, in your opinion, the disadvantages of it? So the floor is yours, Professor.
Thank you so much, dear colleagues, dear guests. In fact, I would like to explain all these questions together. First of all, I would like to make a very short story on the relationship with the Turkish National Committee, of the Turkish National Committee with the International Association. As you know, the association was set up in 1950, and the Turkish National Committee also was one of the founders, as far as I remember. But my first contact started in 1960 with the association, because I joined the faculty staff in those years, and my room was in the Institut de Droit Comparé, today's center. Institut de Droit Comparé, the director was a famous constitutional law professor, and my teacher, Professor Dalvan, was deputy president or something like that. And in those years, the relationship, particularly financial relationship between Turkish National Committee and the association was rather good. But after 1965 and after the financial difficulties of Turkey, these relationships lessened and lessened. We had until in the last years of the 1960s and 1970s, we had only one foreign contact, not with the association, but with Swiss lawyers. So we had Semaine juridique turco-Swiss each 4 years, and Turkish and Swiss lawyers used to come together to discuss the applications of the same rules in Switzerland and in Turkey. In those years, in the 70s, the directors, the presidents, or the directors of the Institut de Droit Comparé, and the president, not the Turkish president, of course, but the director of the Institut de Droit Comparé and other colleagues were not interested in the activities of the association. So they had only one contact, interesting. Each year we used to establish a 3 days symposium with the Cour de Cassation in Ankara, and we usually discussed the recent developments in liability law in Turkey and abroad. But with association, as far as I remember, no contact. So in 1978, I became the president of the Comité National and the director of the Institut de Droit Comparé. And I had problems, financial problems. I had contacts, of course, with Académie Internationale de Droit Comparé and Association Internationale des Sciences Juridiques. Many members of the association were my teachers, because I was student at the Faculté Internationale pour l'Enseignement de l'Europe comparée in Strasbourg, and so I knew many people from the association. But in the first weeks, I was completely disappointed. Nevertheless, the consul, the attaché, lady attaché of the Italian Consulate General in Istanbul assisted me. She said there are bilateral cultural agreements and only support football players or ballet dancers or some professors enjoy these bilateral cultural funds. Why not the lawyers? Then she contacted somewhere, and we got some money, and we began first after 1978, about 1980, let us say, activities with the association. But we had still problems to make payments, yearly payments to the association, because I attended one of the international congress arranged by the Académie Internationale de Droit Comparé. On this occasion, there was a meeting of the association and General Assembly, something like that. One member said Turkey could not enter this meeting because it couldn't pay its yearly cotization or yearly payment. Another problem. Then, however, with the aid of Ms. Rispoli, cultural attaché of Italian Republic of Italy, we could invite very famous Italian colleagues. For instance, Capelletti came to Turkey with Marshal Suborne and with Sacco and with some other well-known Italian lawyers. And after this contact, we tried to find other financial fund. This time I was the legal advisor to the Istanbul Chamber of Commerce in that international relations, and they assisted us. And so with the financial aid of the Istanbul Chamber of Commerce, association became rather active in the early 1990s, let us say. But then, unfortunately, in 1993, I lost my daughter in a terrible traffic accident as a victim, and we could not come ourselves. We established a foundation for the protection of graphic design art in Turkey. So this foundation is dedicated to the development of graphic design in Turkey and abroad. And then the first meeting with the aid also Mr. Mayor Necker, we could arranged a congress, years before a congress, in the list 46, la protection juridique des beaux-arts et de l'art graphique à l'ère d'Internet, Istanbul, 1997. So our contacts were intensified through this foundation and through these activities. And then, because of through of the Istanbul financial aid, financial support, Istanbul Chamber of Commerce, we could, as Turkish National Committee, we could invite several colleagues from several countries. And as a national committee, we were rather active. For instance, I just remember, for instance, because of the Vienna Sales Convention, we had here Professor Elina and Sjef from Germany, with some other colleagues also expert on Vienna Sales Convention. By the way, I was in the Turkish delegation in the international diplomatic conferences on agency in international sale of goods, on applicable law in international sale of goods, and through their assistance we could arrange other activities in Istanbul, and also, but not a congress, just invitations, very short scientific meetings. Then we could, for instance, invited in those years consumer legislation in Turkey, a problem, consumer issues were generally discussed by several circles, and through the aid of the Istanbul Chamber of Commerce, again, we could invite, for instance, my late colleague Aldo Frignani, and for instance, Uwe Blauro, Germany, Eva Pondius, Netherlands, and we could continue. Then another important problem in Turkey in those years, competition law. We could not have a cartel law or a law against unfair competition. Then we could, through the aid of, again, Istanbul Chamber of Commerce, and through, I could get some other funds with support of those funds. We could invite also several colleagues on the consumer law, and we discussed recent developments in consumer law in those years, of course, in the Europe and all over the world, and we could assist the formation of the Turkish law on unfair competition, modeled upon this legislation was modeled upon EU competition rules. In those years, Rome treaty, Article 85-86. However, we also followed Maastricht and then Amsterdam treaties, and we could achieve as the National Committee of the Association the formation of competition law in Turkey. Then in about 20,000, another important thing by chance, let us say, occurred. I was requested to advise legally to the delegation in the United Nations Ancestral Working Group 6. Working Group 6 dealt with, in those years, especially secure transactions. And so then we began to, again, as a Turkish National Committee, to invite many colleagues, more or less after each session in the Working Group 6 to Turkey to discuss the recent, to discuss new developments and the course of the formation of secure transaction. Then in 2010, I was in Washington, D.C. on the occasion of the Congress arranged by the Académie Internationale de Droit, and I became the president of the association. So the date 1910. I was very happy, and because I could act. Then another interesting problem occurred in Turkey, and probably many people knew Del Bosque, the trainer of Beşiktaş Football Club. Beşiktaş Football Club cancelled his training agreement. Then we decided, and of course the issue was brought to Switzerland, and as a last resort, I appeared before a court of arbitration for support. A funny experience in my life. Only I had the time, 5 minutes, to present my objections to the issues, to the decision. Then we decided to discuss this matter in Turkey. And then support law was one of my most important activity as a president of the association. Many colleagues came from all over the world. Particularly, we invited expert colleagues from Italy, from Spain, and from other European and Asian countries. And at the same time, we had contact as the Turkish National Committee of the Association with Austrians. And then we established Austrian-Turkish legal or law days or lawyers' days. Each 2 years, we used to come together, either in Istanbul or in Vienna, and we could discuss recent developments in law, private law, public law, current law, etc. And so during this time also my duties in ancestral continued. By the way, at the same time, I was one of the experts of the medical law, particularly liability of physicians, of physicians and doctors. And then I had also worked, I worked also in Conseil de l'Europe, in the committee director of the bioethics, a new area, and I brought the problems of CDVI, committee director of the bioethics, to Turkey as an activity of the Turkish National Association. In 2013, CORDERO arranged a conference in Mexico City on the cultural property. I was there, and my predecessor was our late colleague, Professor Emeritus. So I also, my successor, SYMEONIDES this time. So I delivered the duties to SYMEONIDES. So these 3 years in my life, as you see from the 1960s to 2013, very close contacts with the association. Financially, despite financial problems, very close relations. So this is the first part of your questions.
A very interesting trajectory.
Now I am coming the second and third questions shortly. Unfortunately, after 2010 or 2015, comparative law began to hold its level, not in Turkey, but all over the world, because I know very well the rise of comparative law on the continent and in the United States, because of partly because of the German German professors who obtained asylum from the States. They died, and the level of comparative law lessened and lessened. Now, I know some colleagues in the States still dealing with the current issues of comparative law, but I remember I missed those days when the comparative law was its zenith. In Turkey also, there were intensive comparative law studies. Still there are, but not purely comparative law, because in Turkey every member of the law schools, not Istanbul University School of Law, but all over the world, should examine foreign law. Because when you write your paper, or when you would like to write your PhD thesis, you had to check Swiss legal literature, then particularly German law books. And I became 2002 Emeritus, and before the year 2002. So, Institute of Compare, unfortunately, before Alilakana, unfortunately, forgot its duties. So, no more Symeon Turkish. With Austrians, sometimes we could come together, and no more invitations on current legal issues from abroad. And then I wrote an article on the rise and fall of comparative law all over the world. Fortunately, the level was not terribly lessened in the Netherlands. And by the way, on the one hand, Academia Internationale de Droit Comparé, on the other hand, our association, were rather active, and they do not lose their levels. That's good. And now the main challenges of comparative law, now as far as I see and as far as I think, should rise comparative law again. I'm coming to the third question, advantages of comparative law. As a comparatist, as far as I know, without comparative law, without international cooperation, without congresses, symposia, or other international contacts among lawyers, among scholars, the improvement of law all over the world would encounter very difficult issues. So then, without comparative law, as far as I say, no nation can develop its legal system. And today, as you see, our colleagues in that explained the new directive on product liability, and so we know by heart that product liability, new product liability directive. Because, why? Because through the Turkish National Committee, we discussed former directive 85/374, and the Turkish product liability law, product safety liability law, is modeled upon the former directive. So now today we had the other member states, of course, will begin their efforts to transform their national laws into their national laws, the provisions, the new rules of the new directive, and it would certainly impact upon the development of Turkish product liability law. So, therefore, I could not imagine any world without comparative legal studies. These are my considerations.
Thank you very much, Professor ÖZSUNAY. I mean, the conclusion says it all. There's no work without comparison of laws. You seemed a bit pessimistic, but I can assure you it's not, the level of comparative law has not lessened. Perhaps many countries or many ministries of education, national ministries of education or law schools do not give the attention that they should. For example, my law school keeps comparative law as an optional course. In my opinion, it should be mandatory. Okay, Prof. achieved that, but yeah, there are not many SACOs in the world. I try to, but there are new approaches, and I like that very much. By comparing with the others, we understand better our own law, and therefore the law in general and its force and its breadth and the way culture itself generates law. Yeah. So,
probably it would rise again, I am sure.
There are always people who, certainly International Association of Legal Science. Thank you. Okay. Let us think. Certainly, the trajectory of your life in comparative law was mostly interesting. Thank you very much for that. And let me turn to Professor GAMBARO. Dear Antonio, would you tell us your own thoughts about the questions? But you can connect them, you do, with your trajectory if you wish, whatever you wish.
Okay, thank you. First of all, would you hear me?
Yes.
Would you hear me?
Yes.
Perfect. So, thank you very much for the invitation, and thank you very much to all the organizers of this important meeting. Well, the first question is a souvenir. When you were president of the IALS, etc. Well, I have to remember that my connection with the IALS started when I became director of scientific studies in 2001, and my first engagement was to organize a meeting in Santa Cruz de Tenerife in October 2001 on land law and in comparative perspective. I've been president of the IALS from 2016 to 2019. I must say honestly that at that time the IALS activity was already in decline due to the lack of funds to organize research and events. This difficulty was compounded by the fact that at the same time the global context of comparative law had became more dynamic, but also more difficult to follow in absence of a significant organizational structures. But the reasons are well known. The effervescence of comparative law studies and researchers was partly driven by the process of European unification, which involved extensive comparative law research. The European Legal Institute, which STIPA is, let me say, one of the dominant figures, is a good example of this effervescence. To a greater extent, was because the process of globalization has significantly increased the need of knowledge of the law in force in almost the entire world. This has led to an inevitable explosion of comparative studies and also publication, with the consequence of an increasing difficulty to keep up to date with the literature, but also has increased the number of organizational network that do comparative law in every field and specialties, from judges to lawyers to all other scientific organizations. So I would say that to this fragmented and complex world, well, to have survived 75 years seems to me to be already an astonishing achievement. So, congratulations for that. Well, coming to the other question, if I can, to go fast. Well, I will say that the main challenge for comparative law, what are currently? First of all, it seems to me that there is a problem of definition of comparative law. Because, thanks to the sinister privilege of age, I can remember that until a few years ago, the concept of legal comparison seems fairly clear. Essentially coincided with the major legal system in the world today, the David famous handbook, plus an open series of sectorial comparison, comparative law, property comparative law, family comparative law, etc. And on the other hand, constitute public comparative law has increasing importance in explore the constitutional and administrative model present in the world. That was mainly because for economics and social analysis in general, the study of the public institution in each country has become central. Well, it seems to me that today the picture has changed and comparison is divided into abstract disciplinary sector, which are a form of harmonization with the traditional legal knowledge. Comparative legal culture, comparative law and literature, comparative law and economics, etc., and also legal anthropology and law and sociology. Well, these are a form of broadening of the cultural horizon of the jurist, even of the practical jurist, of the lawyer. This broadening in turn seems to me to have been functioned by two related acts. First, the complete departure from the closed circle of the national state, in which the knowledge and the formation of the jurist was restricted, and the recognition of the inadequacy of the exclusive normative approach to the understanding of the law in force. Normative approach is no longer sufficient to understand the legal phenomenon. The problem is nowadays to have the information in order to understand the other and to organize a knowledge of another system than others. It seems to me that every legal tradition has created a form of legal mentality. But if we assume that also legal mentality and broader culture are relevant in order to understand the legal system, not only the foreign legal system, but also our own legal system. then this created a problem everywhere. And what I must underline is that nowadays it's well understood that understanding the law is a process of transposing text into rules. In this transposition, that normally was referred as legal interpretation. How the people construct the legal system starting from a legal text. Then there seems to me a general agreement that this is a more complex problem than the subject criteria of interpretation would suggest. But what we mean when we speak about legal mentality? Traditionally in comparative law, legal mentality has been linked with the concept of legal tradition, considering the reformer to be the result of the later. Thus, the legal mentality of a lawyer in London was considered to be the current outcome of the historical evolution of English common law, while on the other hand, a Parisian jurist was the result of a largely indigenous tradition. Hybrid legal traditions were certainly recognized, but most distinctive of this grouping was the fact that the understanding of a legal system through the historical development has created, give rise to a certain disaffection with the exclusive normative approach. The question is, what happens to legal mindset when we recognize that legal knowledge has itself become hybridized with the other form of knowledge, primarily economic knowledge, and then technical knowledge, for instance, in the case of product liability. Normatively, what has become the operational role of comparative law in a context of a theoretical unresolved complexity? Well, this to me, to my mind, these are the main challenges of comparative law. On the third question, I want to start from an observation that deserves to remain unchanged. Namely, the observation that comparative law is indispensable in the training of lawyers in the world today. The motto, know in order to act rationally, always applies. If we don't know, we don't act rationally in every field of the jurisprudence. However, the question remains as to what indisciplinarity slide should be given to comparative teaching. Given that a lawyer will have to deal with cases and issues involving not only legal text or purely legal mindset, but also other technique and other area of knowledge. Accountant, for instance, is very important in many fields of commercial. Apart from that, in terms of scientific knowledge, I would say that in principle, the contribution of comparative linguistics, comparative anthropology, and even comparative literature are essential to try to understand other people's mentalities, and even our own. However, these contributions are fruitful when used to deepen the understanding of current legal mentality at local level. They become simply unmanageable when transposed to a global level. how many things we have to know in order to understand the language, the literature, the psychology, the anthropology, all over in the world. Well, it seems to me that this dilemma has only two ways out. Even we settle for a superficial comparison that is not a real understanding of other systems. Or we wait for the development of artificial intelligence to help us. That's all. Thank you very much.
Thank you very much, dear Professor Gambaro, dear Antonio. I'm thrilled because I use all these examples in my courses because I have since some years a new LLM on comparative studies, and I'm still very much interested in learning. So I often use it as an example. A dialogue I had with a professor, a Swedish professor of Czech origin, if I remember well, back in 2002 in Brussels about methodology and now I'm stuck. My mind is stuck. Comparative law, and he said. Okay, what are you doing? You are professor of what? And he was professor of philosophy of law. And I said, comparative law. Oh, I pity you, he said. You have to read comparative law and legal philosophy and anthropology and history and everything. I have read just legal philosophy. But I said, that's why I'm free, because I have to read all that. And it's a bit masochistic, perhaps, but I'm very happy that I have so many things to learn that probably I shall never learn, but there's so much material to learn. So thank you again. And now I turn to Professor Manet, dear Sjef. Your turn now.
Right. So, in fact, my involvement was in the beginning being a member of the executive committee. Then I became Secretary General, and after that President and now Emeritus President. And what changed? I think in the period that I was President, and also the years before that, the focus was very much on integration of law, legal integration in Europe, globalization, and all the comparative law efforts were aimed at integration. They were there to prepare integration. More European Union law, perhaps a European Civil Code. So basically, it was a period of optimism, but also a period where there was a rising atmosphere of, well, once when we integrate the law, comparative law is no longer necessary, because the law will be the same. And I think that changed drastically. I must say, in about 7 years' time, the world really changed. I don't think we are that optimistic anymore. There are efforts to create integrated law in certain areas. I'll say a few words about that. But given that we more and more stress national identities, that we look more for looking at your own country, your own economy, it means that attempts at integration gradually fade. It means that national laws basically win their importance back, and consequently comparative law does. What also was going on when I became president was, well, our first struggles as lawyers with the internet and everything that had to do with the internet. Only 7 years ago, I was co-reporter for the European Law Institute on a project on whether a transaction on a blockchain was legally valid or not, and what to do with a smart contract, with a legally binding contract. We struggled through that. I've chaired one session where one of my colleagues got so emotional that this colleague walked out of the meeting arguing that anything that happened in a digital environment would not be legally relevant, and any attempt to try to regulate it was denying that reality. Whereas the reality at that moment already was that basically what was happening in the virtual world, digital contracts, blockchain and so on, basically went on whether we lawyers liked it or not. But we thought that once we solved the problems around blockchain and smart contracts, that was it. But we were horribly wrong, and that's also a difference between then and now. Because no one 7 years ago in the legal world saw the consequences of AI and what AI will do and how AI will impact blockchain technology, smart contracts, you name it. And what we also see is when you study the legal aspects of, let's say, these technological developments, that you have to go back to the basics of the law. You have to ask yourself questions like, if you say data ownership, what do I mean by ownership? And then suddenly, that is no longer a legal question, it becomes a philosophical question, a technical question. It becomes a law and question, whether you like it or not. And in order to answer that question, again, you need comparative analysis. You need to understand how the different legal systems react to the incorporation of blockchain transactions. How do they react to smart contracts? That's one thing. Another is climate change. The more we think about the impact of climate change, the more we need to know about what climate change is. We need to be informed as lawyers. Like before we can talk about law and digitalization, we need to know about digitalization. We need to know what we are talking about. So the purely dogmatic approach to law no longer makes any sense at all. It is always law and. I cannot discuss the legal consequences of AI without understanding what AI is. I cannot discuss consequences of climate change and I don't know what's going on. So it's always law and, I think. Not perhaps law and literature. That's interesting as an academic, as an intellectual exercise. But what the law and that I'm talking about is an exercise to understand what is going on so that we as lawyers can react. And comparative law there, I think, is an essential step in your way of thinking. You make things relative, you compare, and you try to find workable solutions. And to me, those are the very short answers of the three questions.
Short, but very succinct. Yeah, otherwise thanks. So, are we ready to take a video? Professor Symeonidis would not make it here, and he preferred to send a video with his answer.
You might need to share the screen with audio option. So you may want to close sharing and now share with the audio.
Thank you.
So you give you the option to, yeah.
I'll sit in the room so I can see that.
You might need to click both of them. Stop sharing. Stop sharing. And then click the two. And let's see what happens. See how share the video. That's fine on it. I don't know what. I can play the audio in my computer. And put it in the microphone.
Dear colleagues and friends, thank you very much for allowing me to join your meeting from a distance. I speak to you from the other side of the earth, from the state of Oregon, from the Pacific coast of the United States, which is approximately 10,000 kilometers away from where you are. I send you my warmest congratulations for the Diamond Jubilee of the International Association of Legal Science. I had the honor of serving as president of this association for 4 years, from 2013 to 17, and also as vice president for the previous 7 years. During my presidency, we organized 3 congresses, one in Turin, another in Hamburg, and another in St. Petersburg, and our themes were legal pluralism, the role of legislators, judges, and professors in the legal system, and the globalization of private international law. I have fond memories from those congresses, but in the few minutes that I was given, I cannot talk about them. I will instead talk more generally about the evolution of compounded law, not in the 75-year lifespan of this association, you see I'm not that old, but during the 50 years of my teaching career, which, by the way, was just completed with my retirement last June. And because most of my teaching was in the United States, I will talk only about that country. When I started teaching 50 years ago, a course in comparative law was a luxury that only a few American law schools could afford, no more than 20 law schools. And the professors who taught comparative law at the time were invariably foreign-born immigrants like me who had crossed the Atlantic from Europe in search of wider horizons. The second feature of comparative law during that period was that all the professors who taught it were what we call privatists, and consequently comparative law was confined to private law, in fact only some parts of it like contract and torts. Now, fast forward to today, and what do you see? A totally different and much richer picture. Now, every American law school has not just one course in comparative law, but several such courses, and more importantly, more regular courses that are taught from a comparative angle. The people who teach these courses today are no longer the few immigrants with foreign accents, but American-born and educated professors, and most of them have doctoral degrees in other disciplines in addition to law. And these professors no longer confine themselves to some fields of private law. Instead, they now teach courses in comparative constitutional law, comparative public law, comparative environmental law, comparative procedure, and so on. And most of these courses are taught from an interdisciplinary angle. It is not just law alone anymore, but law and sociology or anthropology or philosophy or political science or literature. Now, are we better off today than in the good old days? In my view, yes. Today, comparative law is a much richer and broader field than it was then. It is also a much more effective and insightful instrument for training the legal mind which in my view is one, but not the only, mission of comparative law. It has always been true that by learning about other legal systems, a law student becomes a better lawyer. What is new is that with the assistance of other disciplines such as sociology or anthropology, we, the teachers, can understand other legal systems better, and we can then pass on that understanding to our students, making them even better lawyers. In closing, I think that in its 75-year lifespan, our association has contributed in its own way to the enrichment of comparative law. And for that, Madam President, Mr. Secretary, and dear colleagues and friends, you have every reason to celebrate and to be proud. I wish you another 75 productive years in service to the cause and mission of comparative law and through it to international understanding. Thank you very much for your attention.
We can say. I remained alone here for the obvious reasons. But let me see whether yeah. Was it? Yeah. He hears me probably. This is okay. So, I'm very happy for all this, and thank you. I thank the speakers. I thank the again the Turkish colleagues and the Center of Comparative Law in the University, and as I give the floor to Jorge, to Jorge SÁNCHEZ, CORDERO, and to Oleksiy KRESIN for the rest of the evening, the afternoon. Okay?
Last but not least. Well, this is points. It is both a great honor and sincere pleasure to introduce Professor KRESIN, a distinguished scholar and jurist from Ukraine, whose work and intellectual leadership have earned him the highest regards in the international legal community. Professor KRESIN has developed his career to exploring the foundations and frontiers of comparative and international law. His research delves deeply into different and how different legal systems interact, influence one another, and evolve in a dialogue with changing global realities. Through his scholarship. He reminds us that law is not only a technical instrument, but also a living reflection of culture, history, and shared human values. Over the years, Prof. KRESIN has authored and co-authored numerous publications that have made a lasting contribution to our understanding of comparative legal traditions and legal theory. His analysis combined remarkable academic rigor with an exceptional sense of perspective, bridging Eastern European legal thought with the broader currents of global jurisprudence. But beyond his written work, Professor KRESIN has been an active and respected participant in many international legal forums, scholarly networks. His thoughtful interventions and diplomatic approach have made him a trusted voice in discussions that seek to strengthen cooperation between national and international legal communities. But also distinguishes Professor KRESIN is not only his scholarship, but his personal qualities, his generosity of spirit, his quiet determination, and his ability to listen and engage with others in a way that truly builds understanding. He embodies the spirit of collegiality and openness that lies at the heart of academic exchange. Today, we are privileged to welcome him to our center. Have no doubt that his reflections will offer us not only profound insights into the law, but also a broader vision of how comparative legal scholarships can help foster mutual respect, dialogue, and cooperation among nations. Please join me in giving a warm welcome to Professor KRESIN, an eminent juror, an inspiring academic, and a true friend of international legal scholarship.
Thank you so much. So much about me, and I'm not sure I have enough time. I'm speaking the last, and I'm sure that you are tired. What I'm sure about is that you are tired, pretty tired. And thankful to Jorge for so honorable presentation. So I will speak about the role and place of UNESCO and IALS in the development of comparative law. And I will speak only with my slides, because I have to understand your conditions. Okay, so the first, let us talk about the concept of UNESCO and social sciences. And according to UNESCO Constitution that was written and proposed in 1945, conflicts between peoples begin in the minds because of the ignorance. And the aim of the organization is mutual knowledge and understanding between peoples to advance international peace with cooperation in the fields of education, science, and culture. What about social and human sciences in this situation? In the first sessions of the first meetings of the General Conference of UNESCO, social and human sciences were acknowledged as the same scientific as natural and technical ones. But they, social and human sciences, are a bridge between the fact and the value. That was the idea of the first general director of UNESCO, Sir Julian Huxley, and it was widely accepted. What we have to do? We have to promote comparative methodology paradigm. And the shift should be, instead of the genealogical tree, instead of evolutionism and divergence, the paradigm of the network. And what is the aim? To form a single world culture. And I have to say that UNESCO Secretariat in 1946, by the way, under the influence of KRESIN, recognized two legal disciplines among the social sciences. One is international law and one is comparative law. So only two disciplines were recognized to be scientific, to be academical among legal ones. And UNESCO General Conference in 1946 decided to stimulate scientific centers in the field of social sciences and to initiate the international conference and study on comparative law and international law. Why? Because it was proclaimed during the discussions that only comparative law, international law, and a little bit later it was said also about philosophy of law, only these disciplines transcend the national doctrine and practice. And so they could pretend to be scientific. Next, about the concept of comparative law association attached to UNESCO. The first project, according to instructions of the Secretariat of UNESCO, the first project was proposed in 1947 by René David. And according to his project, comparative law is a means for understanding between peoples through knowledge, and the aim of comparative law is not unification, but the formation of universal legal science. And his idea was to create the International Center for Comparative Law with such aims as scientific, educational, publishing, and information resource. And some other projects of the same year that were submitted to General Secretary of UNESCO. One of the authors was Jules. And in his project he emphasized that comparative jurisprudence, and he called this comparative jurisprudence, is a method of improving law and forming a universal science of law. And he proposed, Jules Besdevan proposed a new axiological vision of comparative law as a modern form of legal humanism. And he stressed a need for comparative law center that should be a coordination plan, and the need for international faculty of comparative law. He was the first to stress such a need for international faculty. And the same year, a General Conference of UNESCO decided to approve a special program in comparative international law with the aim to raise legal science to the international level. And according to documents of this General Conference, comparative law is in closer conformity with UNESCO field and a connecting link between the social sciences and law. And one of the decisions of the General Conference was to create an organization with coordination and research functions. The next point that is important in its principle is a meeting that was held under auspices of UNESCO in March 1949. I will tell about this more. First, this year, the beginning of 1949, we can witness a number of projects and proposals for the creation of the association. By the way, the first name of the association that was approved already in 1947 was International Association of Comparative Law. International Association of Comparative Law. It was first official name for the association. And only the second was International Committee of Comparative Law. Does it matter? The authors of projects and proposals for the creation of association in 1949 were René David, Felipe de Sola Canizares, Eduardo Couture, Enrique Astiria, and Mark Ansel. And when opening this meeting, the biggest meeting and the most important meeting in the history of the association, UNESCO Director General Jane Bodek told that only the use of the comparative method, which forms comparative law, transforms the study of law into an international science. During the meeting, which ideas were the most important? International tensions can be increased not with differences in law, but with misunderstanding or superficial knowledge. This idea was accorded by René David. The aim of future association is not the unification of law, but to throw light on existing differences by examining the fundamental economic, political, philosophic, and sociological ideas on which they were based. I'm citing from Ernst Rabel. The next idea, the fallacy and inadmissibility of the identification of comparative law and foreign law. The author of this passage is Isaac Kish from Netherlands. Next, inadmissibility of the ignoring the social context of the development of law. The authors were Jean-Pauline Liboyer and Tullio Ascarelli. The need to work out a single terminology, to unify the methodology, to teach comparative law courses at all faculties, and to create chairs. These ideas were the most important. And what about the creation of International Committee, the new name, the second name of the association, International Committee of Comparative Law? So in 1949, such structures as an advisory committee were become stable, and first 4 national committees were created, and as Professor ÖZSUNAY told, one of the first was a Turkish committee. In July 1950, it was a meeting of advisory and executive committees in London, and International Committee of Comparative Law was founded under the leadership of Léon Jules de la Morellier, the Dean of Faculty of Law of Paris University. The first statute was approved, and according to this statute, International Committee of Comparative Law promotes knowledge and mutual understanding between nations and encourages the spread of culture by developing the study of foreign law through the world and the use of comparative method in legal science. And UNESCO General Conference meetings of 1950 and 1951 decided to study the teaching of social sciences for its improvement. And the same, it was decided that the International Committee of Comparative Law will study the teaching of comparative law, of international law, of philosophy of law in the countries of the world. And the methodological basis was approved not only for legal studies, but for all comparative studies. And UNESCO was gave life to many comparative associations, for example, comparative economics and so on. So, methodological basis for all cross-national research was approved. It's preparing national reports according to the same structure and the comparative analysis. And the same year, we can speak about the meeting of the committee. And the priorities, the first priorities of the International Committee of Comparative Law were established. A reference, preparing the reference book on law in force, reference books on legal science, education and information in different countries, and to study the state of teaching of comparative law and philosophy of law. Next, what first projects of International Committee in first years were most important is teaching comparative law. The preliminary report was prepared in 1951, and the author of this report was Jean-Pauline Boyer. And what is especially important that it was not only a report of teaching comparative law in different countries, but two programs, two model programs, teaching programs were added to the report of two comparative disciplines. The general theory of comparative law, it's the first discipline that was proposed for the implementation, for the realization in different universities in different countries, and the course of comparative law. And I want to say that both programs were taken from Mexico, from Mexican authors. Anyway, everything matters. The final study of the state of the teaching of comparative law in the world was prepared in 1954, and the new edition in 1973. And the author of both these studies was Charles Eisenman. It's a monography, in the wall of monography study, and it's very impressive. But anyway, what about the general ideas, the most important ideas? The true science of law could be built only on comparative basis. The aim of the law faculties is scientific teaching, which implies the intrinsic value of knowledge, a general understanding of law in its totality, and necessarily involves the study of foreign law, comparative law, and the history of law. Among other projects should be noted the index for searching for information on the legislation of countries of the world, general index, of course, like preliminary, introductions to the legal systems of Denmark, Norway, Iceland that were published under auspices of committee, the bibliography on the law of France and Canada, and the translation of the textbook on comparative law by Harold Cook Hatterich into French. And as we know, in March 1955, the name was changed to contemporary one, to the International Association of Legal Science. I'm not speaking more because not to take your time about different details of programs, some scientific elements, some axiological elements of these programs, and let it be the first program of UNESCO, of IALS at all. But what are the conclusions, the short conclusions? Comparative law as a scholarly discipline was recognized at the highest level in the system of United Nations agencies. Second, the scholarly potential development is visible at that time. The theory of differences was proclaimed, the pluralistic mentality of comparativists, the diversity and equal value of legal systems were substantiated. And we can speak about the rejection of the orientation towards unification and creation of world law. Knowledge of legal systems involves understanding That was the idea. Not only knowledge, but it involves understanding. And the idea of the network paradigm when studying legal system, not the hierarchy, but network, where every legal system has its value. Next, the ideas about teaching comparative law, the ideas of introducing a course in comparative law at all law faculties, of creating the International Faculty of Comparative Law, and the creation and the proposition of the model teaching programs. That was important. Yeah, and the last, fourth, the axiology. The axiology of comparative law, we can speak about the formation of the axiology of comparative law. And the main ideas in this sphere is overcoming misunderstanding and neglect between peoples, pluralism and respect for differences, polylogue of legal systems, and the understanding of comparative jurisprudence or comparative law as a modern form of legal humanism. So, thank you for the attention. Any questions?
Thank you very much. Thank you very much, Oleksiy, for your presentation about the foundational years of the association. I was intrigued by the Mexican connection, to put it in. I recall that several Spaniards were emigres that had gone to Mexico, and there at UNAM, at the University Autónoma Nacional, they worked in the Comparative Law Institute that would quickly have a bulletin. And I was curious if you were able to trace to what extent was it the element of the emigre that shaped that comparative narrative. Of course, this would be an anecdote, perhaps, but it could help us understand the broader picture, because other emigres went, as we know, to the US, to England, but also many went to Latin America. I can think of Córdoba in Argentina. I can think of Goldschmidt, the Goldschmidt that went from Uruguay to Córdoba in Argentina, from there to Caracas. So if you could tell us a little bit more about that emigre element. Thank you.
Thank you. What I have to tell, I don't want to say pathetic words, but in fact, we have a lost continent of the history of comparative law. And by the way, the history of IALS. It's a really lost continent of ideas, of organizations, of initiatives. We know a few. We know really a few about real history of comparative law. It's a pity. It's a pity. I can speak about this for hours and with some examples. But if you are speaking about Spanish-speaking world and Latin America, first I want to name these authors of these courses. General Theory of Comparative Law was proposed, the course, by Felipe Sánchez Roman, and the course of Comparative Law, Eduardo Trigueros Sarabia. Anyway, both were, the first was at that time a professor, and the second just doctor. Yes, it's interesting phenomena, not only in comparative law, but also in international law, maybe in some other disciplines and some other spheres also. That it was a real renaissance in Latin America in the beginning of 20th century, or new foundations, not renaissance, because renaissance is of something old. It's a creation of a number of institutes, and very effective ones. I don't know how it's connected with developments in Spain, for example. But about Spain, we know nothing about the history of comparative law in Spain. For example, first chairs of comparative law in Spain were created in 1840s. And nobody is writing about this. According to many scholars, comparative law not existed at that time. But chairs of comparative law already existed. I'm not speaking about Germany or Italy, some initiatives were even earlier, but Spain is a very good example that we know nothing about the history of comparative law. And it was not surprisingly that at the beginning of 12th century and the first half of 12th century, the schools of comparative law and international law in Latin America were really prominent and very interesting.
But may I add something according to highlight why Mexico? Well, during the Spanish Civil War, Mexico opened all its doors to the Spanish intellectuals. Migration was very important to my country, and we hosted many intellectuals in my country. Among others, Felipe Santos. The first institute in the region in Latin America was founded by Felipe Santos, that he was a Spanish scholar, a Spanish. That is why Mexico was trying to lead first the research of comparative law, and then to try to foster the teaching of comparative law, first in Mexico, and then in the whole Latin America area.
But also Argentina, Brazil, different institutes of comparative law and of international law, and a number of very interesting scholars.
Just follow up, thank you. Indeed, Sánchez Román was a degree. That's why I was pointing to my question. And perhaps the reason why they don't refer to comparative laws because they refer to legislación comparada. That is the earlier stage. That might explain why this. But indeed, in Spain, legislación comparada in Latin America was very strong. We had the occasion to speak about this on 100 years of the Lyon Institute, where we saw the connections between Lambert and Couture, for example, that you mentioned, and many other colleagues in the Americas and many Emeritus. So thank you for your elaboration.
Just to respond, but don't forget that the teaching of comparative law started in 1820s. And first chairs of comparative law were created in 1820s. And chairs in comparative legal history were created even before, starting from 1818. Okay, sorry.
May I ask you, I was surprised to hear you saying that the first seat in Spain of comparative law was started.
Chair.
Started when?
At least, because I'm not a specialist of that period, I have researched the previous period, but anyway, as far as I know, at least from 1840s, first chairs of comparative law, 1840s. They were not the first in the world. 1840s. Yeah, it's true. It's true. And if you're speaking about Europe, so as I told, first chairs of comparative law were from 1820s in Germany. In different, Germany was not a unified country, but in German countries, German-speaking countries, let it be. And I saw the programs of disciplines. I saw the sources that were used, other things that were announced. So it's not just because somebody told. Yes, comparative legal history from 1818 and comparative law from 1820s.
This really is surprising for me to explain that not even civil code.
Civil code, yes. The history of civil code is more interesting because the first idea of Napoleon was not to create a completely new law, but to compare. And the first center of comparative law is a center created by Napoleon. And from 1801 to 1804, 3 years of functioning of this center.
Oleksiy, thank you very much. It's a very informative presentation, and particularly on 75 years of IALS. And I think what you particularly brought to the fore, notwithstanding what you flagged about the longer history of comparative law as a discipline, and picking up on Agustin's observations about the rise and then the zenith and the fall of comparative law at large. But what you clearly identified was that UNESCO identified comparative law as a tool for achieving the sorts of outcomes and the sort of peace that was being sought through the establishment of what is now the International Science Council and the efforts there. And it does seem to me that drawing on that and strengthening that, going back to the things that you shared with us in terms of the goals of UNESCO, the aims of the International Science Council, and I understand that already the ISC draws on the IALS quite actively, particularly in recent times. These things seem to me to be a way forward for moving beyond certainly the way in which there's a little bit of stagnation, perhaps, number one, and number two as well, the fact that now everybody seems to be a comparativist. And the downfall of that, to my mind, is that there can be, you can be comparing chalk and cheese rather than necessarily understanding, as we're all aware, the importance of similarities and differences. So thank you so much for synthesizing that. I think that's been a really important contribution.
Thank you for this remark. The idea that IALS was not the ordinary association. And the history of IALS, it's not just institutional history. This surname, the next surname, and that's all. It's a history of ideas. And discussions in IALS, especially on early stage, gave very serious impacts. And hundreds of people were involved. Hundreds of people from at least 40 states. At that time. It's before decolonization, so 40 states, it's enough.
Yes, precisely on this point, I would like you to know, to tell us a little bit, what did you find about... So precisely on this point, I would like to ask you, what did you find about decolonization? Was it discussed at that point? Because it's a crucial moment, actually. So I'm a bit curious whether the international committee and then the association immediately took up this topic, or was embarrassed and did not discuss it, or what?
First, international association took this topic, or topics, let it be topics, the sphere a little bit later, but UNESCO was involved, and IALS was involved with the projects like North-South. It was a long project of UNESCO, at least for a decade. And the International Association was included, and there were policy papers, different other things, let it be in simple way, what to do with the development of law of new states, what to propose, which programs should be proposed and financed by international organizations, and so on and so on. About Africa, at least 5 projects that led the International Session of Legal Science were connected with Africa right in the decades of decolonization. But it was never the general topic, decolonization and what to do with colonialism. No, but separate issues, and they were all the time involved. And by the way, International Association, it was not publicly but I saw in the document even lobbied some projects of African, for example, in Asian countries, lobbied at the level of Secretary General of UNESCO, proposed for to find finance other things. So the international association all the time had a very strict and small budget, really very strict and small. Consisted of two parts. One part is at least at the early stage, I don't know, some decades later, salary. From the beginning it was a salary for 3 people, and that's all. And the second, sometimes some expenses for moving, for taking part in some gatherings, meetings. And the second part is the financiation for the concrete projects. And this financiation was all the time very tight, very tight. So international association, you know, was like a snake with this short funds, but it worked officially, unofficially, lobbying, trying, sometimes receiving some sponsor support and so on. For example, just to understand the financiation of projects, we today discussed the International Encyclopedia of Comparative Law. The issue of financing this encyclopedia was issue for many years, and international to find these costs. An international association lobbied this issue with Ford Foundation, with different other foundations for years. And some letters were preserved luckily in archives. So international association was in the course of decolonization agenda for sure. Thank you. Maybe somebody else? You are tired. I'm sorry.
A very last comment. A Jewish, a Mexican Jewish, in the 50s, was the general director of UNESCO. And Francisco also, well, we pushed a little bit.
Just one final. Just one final question about what you've been doing in terms of finding the archive for this, for example, the 40 countries and the answer to Michelle's question and these others. The challenge of doing archival work, if you could share a little bit,
the challenge of
doing archival work to come up with the findings that you have done in these challenging times.
It's really a challenge. UNESCO itself digitalized some documents, but a few. The same, UNESCO digitalized a part of editions under its auspice. And some of the editions are editions of International Association of Legal Sciences. But it's just a few, And it's difficult to find any system. If you will speak in figures, in numbers, UNESCO digitalized about 5% of archives. 5%. And nobody lobbied digitalization of documents of International Association of Legal Sciences. And so we have no own archive. It's a story of many scientific organizations. We are not the one, not unique in this. But a number, I mean hundreds, or maybe even thousands who know of documents that are connected with IALS are stored in UNESCO archives. And these archives are not systematized properly. So you have to speak with the staff, you have to work with the staff for longer time before coming. But it's a treasury box for us. We can find something. So we spoke, you and me, it's our task to digitalize documents and digitalize editions. Because at least because they were done in the situation of total scrutiny of in very difficult conditions with only naked enthusiasm of scholars of that time.
Don't move, please. Perhaps. I mean, you had said something about the family photo.
Yes.
So that's why you had said.